I'm Dave Mullins. I'm a podiatric surgeon and healthcare attorney in Northern California. I'm also the author of the book, How to Win Medicare Appeals, published by the American Bar Association. This podcast is based on that book, and this is episode number 5 of the podcast. Let's get started. Why is it most logical to send your complete letter brief, meaning the letter plus all the supporting evidence, to the qualified independent contractor? Well, if you know that all of your evidence has to be submitted to the QIC for the second level reconsideration appeal, and you now know that all of your evidence has to be submitted to the QIC for the second level reconsideration appeal, why would you ever submit that evidence without a letter explaining the evidence? Hopefully you wouldn't. What happens without a letter? Without a letter explaining the patient care documents, meaning the documents you've copied from the patient's chart, there's nothing to tie those documents together. And do not underestimate the administrative law judge's lack of medical knowledge. The attorneys always think they know and understand the medicine. And the providers, meaning the doctors, always think they know and understand the law. In 10 out of 9 cases, you heard that right, in 10 out of 9 cases, neither is correct. You need the letter along with the evidence to win your appeal. Will an overworked administrative law judge analyze a pile of unexplained documents from a patient's chart? Not only unlikely, it's just not going to happen. The ALJs don't have the time. How does the letter portion of the letter brief help you win payment of your denied claim? The letter portion of the letter brief explains all of your arguments in favor of payment, and the letter portion of the letter brief acts as the roadmap through all of your attached evidence supporting payment. What's going to be our basic rule regarding ALJ appeals? If there's anything you can do to make it easier for the ALJ to decide in your favor, do it. Why are supporting documents always easy to obtain? You have access to all of the documents in the patient's chart. In addition, your client provider, whose claim was denied, can and will produce the articles, textbook sections, and standard of care statements that you need for your letter. Why will your client provider produce the articles, textbook sections, and standard of care statements that you need for the letter brief? Because for the client provider, this is never business. It's always personal. The providers feel personally insulted that Medicare has decided to deny payment for the service they provided in good faith. So they're always going to be in your corner, and they're always going to be willing to provide you with this information that you need. Why do the appeals get a lot easier as you represent clients over and over again? I think this will come as no surprise. Every provider, I don't care what provider type we're talking about, every provider has a top 10 list of denied codes that account for more than 90% of all of their claim denials. And I don't have to explain to you that once you've appealed the same code for a provider on 5 or 6 or 7 occasions, this process gets a lot easier. At that point, you know more about that code than the provider does. What questions should you be asking yourself as you write the letter portion of the letter brief? You want to write it's obvious. You want to answer the question, what would convince the administrative law judge to award payment? And you want to write to convince the ALJ that the denied service was medically reasonable and necessary, and you want a right to convince the ALJ that the MAC's denial reasons were wrongly applied or shouldn't be applied to your claim. Why am I not saying that you should write to convince the ALJ that the MAC's denial reasons were wrong? If you're looking at this episode with a friend and you're both either doing Medicare denials or you want to do Medicare denials in the form of appeals, wake that friend up if the friend's sleeping. This is way too important to slide for anyone to sleep through. An ALJ does not have the authority to decide in your favor based on a conclusion by the administrative law judge that the MAC's denial reasons are wrong, even when the ALJ firmly believes the MAC denial reasons are wrong. An ALJ can only rule in your favor based on a conclusion that the MAC's denial reasons were wrongly applied, or, much more commonly, that the MAC's denial reasons should not be applied in your case. Please take a look at How to Win Medicare Appeals, page 123, question and answer set 64, 65, and 66 for a longer discussion of this topic. You need to understand this thoroughly. You never want to argue in a letter brief that the MAC's denial reasons were wrong, and you never, ever, ever want to find yourself arguing during an ALJ hearing to the ALJ that the MAC's denial reasons are wrong. The ALJ simply can't rule in your favor on that basis. That's it for this episode. I'll see you the next time.